everybody. Today we'll be discussing a new issue that is affecting contemporary Indian society, and that is human dignity. Like in the last 2 weeks where we discussed privacy over the course of 2 talks like this, human dignity too will be divided into 2 parts. Today we'll be talking in general about what human dignity is and its place in the Indian Constitution. Now, though human dignity has not generally been a contentious issue, because in general, of course, across countries in varying degrees, there has been an acceptance of the inherent and intrinsic worth and value of all human beings just for the reason that they are human beings, which is a Kantian perspective. Human dignity has been adopted and elaborated in different ways across different constitutions and international conventions and sectoral treaties. Now, perhaps the most important document that deals with human dignity and that accepts its essentiality within human rights is the Universal Declaration of Human Rights, or the UDHR, which accepts human dignity as a central constitutive value. But even though the UDHR does give a lot of importance to human dignity, it doesn't particularly define the concept. And so the concept remains deeply philosophical and amorphous. Now, of course, there are good sides and bad sides to this. So for critics, the reason why human dignity has been difficult to integrate into municipal law or domestic constitutions or strict legality is because of how amorphous it is, how abstract as a concept it is. Critics also fear that an overall focus on human dignity could also lead to judicial partiality and could also allow dignity to be subsumed by fundamental rights. So this is on one side of the story. However, there have been many positive consequences of the amorphousness of the philosophical nature of the concept of human dignity. Now, after the Second World War, when the United Nations was formed and to essentially ensure that such horrors never occur again, there also came the Cold War. Now, the conception of human dignity became very, very useful then, because it would allow there to be a reconciliation between differing ideological perspectives regarding the economy, regarding societal organization, regarding polity. And that is because for both the camps, whether it be for the Soviet camp or the American camp, for both the camps during the Cold War, where they were divided and undergoing ideological hostilities across a variety of themes, the conception of human dignity provided a common ground for them to agree on, for there to be negotiation, for there to be discussion, for there to be debate. Because regardless of whatever ideological beliefs that either of the camps had or either of the blocs had, there was a basic agreement that there is an intrinsic worth of human beings that has to be recognized in different ways. So the conception of human dignity became very convenient during the Cold War for individuals and policymakers and politicians on both sides, because in the end it agreed a common ground, and from there other common grounds could be found. Now, the conception of human dignity is very complicated and everybody has had different perceptions of it. Of course, there is one perception of human dignity which is quite Eurocentric in the way that it is defined, the way that the West defines it, with several central values of equality, justice and liberty. And that conception of human dignity, though it has been accepted by most of the world, contemporary scholars believe that a more plural and heterogeneous conception of human dignity is required, because the conception of dignity, because it is so deeply ingrained in society, because after all it has got to do with the inherent worth of human beings as they are, the conception needs to be plural because it is associated with different traditions and social mores and cultures and other social values. So these kind of scholars, they advocate for a more integrative, more holistic idea of human dignity, and they believe that looking at human dignity as a sum of what it means across different cultures, rather than one culture hegemonically imposing it on the rest of the world, would perhaps allow human dignity to be better understood and comprehended and integrated into domestic or municipal law. In general, there are 3 basic conceptions of human dignity. The first is a negative conception, which essentially talks about the removal or the restriction of the state's arbitrary interference into the private spheres of human life. The positive conception of human dignity talks about affirmative action and policies that the state would take to assure that individuals within their territories are able to live a dignified life. And the third and radically different conception of human dignity, which strives to reconcile and bring an equilibrium between universalism and relativism, tries to look at individuals and their differences and their distinctnesses as completely unique in their own way and as deserving of protection by the state and by other non-state organizations as well. So this is it for human dignity as a conception in the international sphere. Now, when we come to the development of human dignity in India, essentially 4 factors are important to note. The first is that human dignity and the fight or the striving for human dignity was central to our independence movement. The colonial rule humiliated and subjugated what they call the natives, which were us Indians. So of course, that was the complete other of human dignity, the complete opposite of human dignity. So the purpose, of course, of finding freedom and forming a new nation was to build a country where every Indian is able to live a dignified life, not as subject people, but as autonomous human beings in themselves. This is one. The second thing is that the independence movement and the constitution that arose from it also provided a new perspective to human dignity in the way that it also allowed the eschewing, at least legally, of social evils like untouchability or other kinds of discrimination. So even for these groups of people, whether it be the indigenous people, the women, the ex-untouchables, or everybody else at the lowest position or the lowest rung of the caste hierarchy, these individuals were also provided a soteriological project through the conception of human dignity, because it would allow, the constitution would allow the acceptance of a new range of human rights that would try to move away from the earlier established social inequalities that were pervasive in India. The third thing that we have to remember about human dignity in the Indian constitution is that perhaps it's a fact that a lot of people forget. But because the end of the Second World War and our independence occurred at around the same time, the Indian constitution makers accepted human dignity into our constitution at very much around the same time where the UDHR did. So this is a fact that is often ignored, but it's extremely important if we have to view the progressive outlook and the vision that the makers of our constitution had for our country. The final thing that we have to remember is that the conception of human dignity within the Indian constitution is not a singular concept. It hasn't arisen from one single philosopher, from one single politician. It is not that it is only a concept that has been defined by M.K. Gandhi, or it is only a concept that has been defined by Bhimrao Ambedkar. The conception of human dignity in our constitution is a deeply, deeply holistic one, and that was the effort of the makers of the constitution to provide a concept that is specific but still amorphous enough so that it is able to adapt to the changing circumstances of our country, and they felt that the constitution would be able to deal with our changing context. Now, of course, human dignity, the word dignity is not mentioned in the constitution other than in the preamble, where the words are fraternity assuring the dignity of the individual. Now, of course, the combination between fraternity and dignity has not been clarified except due to the 42nd Amendment, which was passed during the emergency era, which also added and the unity and integrity of the nation. Now, of course, for most scholars, there is nothing prima facie in the conception of human dignity that separates it or that excludes it from also allowing or from also contributing to the unity and integrity of the nation. But they, of course, believe that because this was the time of the emergency and the Indira Gandhi government was keen to ensure that individual liberties are not allowed to exist unrestrictedly, that was the reason that this amendment was put in. The 42nd Amendment also instituted what they called Part 4A or fundamental duties, which were non-enforceable and non-justiciable duties that every Indian citizen would have to follow. So, of course, even though they were non-enforceable, their very presence in the constitution has allowed the passing of various laws and judicial actions to ensure that they be implemented. And it is here that perhaps the combination or the connection between fraternity and human dignity becomes clear, because the fundamental duties do talk about the protection of women, of indigenous people, of our composite culture, of the environment, and all of these things. And it is true that, of course, if the state or if individuals are able to do all of these things, are able to engage in all of these things adequately, of course there would be the achievement of protecting human dignity. So this is one side of the story. However, for most scholars, the loudest space in which human dignity or the dignitarian concerns of our makers of the Constitution have become evident is in part 3, or our fundamental rights. Now, our fundamental rights don't ever mention the word dignity. But for everybody who ever studies the Constitution, every provision of the Constitution, especially in our fundamental rights, deals with the securing of dignity to all citizens, or in fact in some fundamental rights to all individuals who are presently in India. So if we look at Articles 14 and 15, which are the rights to equality, where they are preventing and making specific provisions against caste-based apartheid, ensuring that individuals across castes, across religions, across genders are afforded and are allowed access to all places that are made for public use, maintained wholly or partly out of government funds. That in itself is a securing of human dignity, because untouchability is one, or the differential treatment of individuals who belong to the lower rungs of the caste hierarchy, is an absolute other of human dignity. Untouchability especially, and this is why Article 17 becomes important, because it abolishes the practice of untouchability and punishes any discrimination that occurs due to it without any restrictions. This is important because untouchability is the absolute other of dignity, because it actually treats and believes that a group of people are less than human. They are less than deserving of similar faculties of reasoning and similar access to various other civic goods that everybody else has. Similarly, we can also speak about the various freedoms that are mentioned in Article 19, whether it be the freedom of speech, the freedom of movement, of association, as well as the freedom of religion that is mentioned in Article 25 and 24. And in these cases, human dignity becomes also important, because the freedom of conscience also is an important aspect of a dignified life. It is in these cases that human dignity becomes an emancipatory project, a soteriological project that would lead to the betterment of individual personality. Even if we look at 23 and 24, which are the rights against exploitation, where there is a prohibition of bonded labor or of forced labor, or in fact even labor where the payment is below the national minimum wage. All of these become rights that secure the dignity and the inherent worth of all human beings. So, constitutionally speaking, where we are looking at just the provisions of the Constitution, there has of course been a debate that do fundamental rights give rise to human dignity, or has dignity given rise to fundamental rights? In the contemporary times, scholars believe that fundamental rights have arisen out of the dignitarian concerns of the makers of the Constitution. In every fundamental right, there is the belief and the absolute vision that in the India that the makers of the Constitution are envisioning, every individual would have a protected and secured human dignity for themselves. Now, when we talk about the judicial history or the juris-generative history of human dignity in our Indian judiciary, we have to essentially look at the development of the power of judicial review of the Supreme Court, as well as the conception of public interest litigations. Now, human dignity was not brought up a lot before the Keshavananda Bharati verdict, except in cases of abjurations of Article 15, Article 16, Article 14 or Article 17. However, the Keshavananda Bharati verdict established human dignity as one of the most important features of the basic structure of the Constitution. Now, with the development of the power of constitutional judicial review, especially fundamental rights review, it has allowed the judiciary a near sovereign role in being able to either prohibit or strongly disagree or strike down any governmental action that they believe is abjuring or injuring to human dignity. On the other side, when the courts realize that often for a lot of poor people, for a lot of destitute people, whether due to ignorance or indigence or apathy, or just because they don't know or they don't have the financial resources to justice, they were being denied justice. So the rising of the public interest litigation, or the guarantee of free legal aid or speedy trial, these were also acceptances by the judiciary that human dignity is integral to the conception of justice. Perhaps the most important reframing of the way that we view Article 21, and perhaps human dignity is most clearly ingrained in Article 21, which is the right to life and personal liberty, because what is a worthwhile life if it is not a dignified life? And indeed the Constitution has, of course, interpreted over the ages Article 21 to essentially also be entailing a dignified life. And it is here where questions of manual scavenging or euthanasia come in, which we will be discussing in the next talk. So in all of these cases, it became essentially clear that the judiciary saw as its purpose that human dignity is important to guarantee to all Indian citizens. In the Maneka Gandhi versus Union of India case, where the conception of procedure established by law was replaced by the due process of law, which is essentially a fair procedure established by law to deny an individual legally of their life and personal liberty, that was perhaps the largest conception or largest reformulation of the conception of human dignity in our constitution. So of course there is a lag here between, of course, what governments talk about human dignity and how it has been established or integrated into society. For example, a lot of governments will of course condemn torture, but will engage in it within their own countries. So there is, of course, a difference between the dignitarian concerns strictly constituted within the constitution or dignitarian concerns also available in society. But in India, an absolute slew of legislations that have been passed by varying governments, successive governments, do prove that there is serious dignitarian concerns that are followed by the Indian government, by the Indian judiciary. And this is extremely important because India did inherit a variety of social evils and social inequalities such as caste-based apartheid or gender-based apartheid or religion-based apartheid from the colonial Raj, which still continues to this day. So if there is at least a formal recognition of dignitarian concerns, one can hope that this will eventually translate into societal reflections as well.